Hi, good afternoon. Today is May 27th, 2026, and it is 4:26 p.m. Central Time. My name is Rinaldo J. Aguemarcano, and I'm recording this from my office located at the 2302 Britton Ridge Drive, Terry, Texas 77494. And this property is located 300 feet away from the residence of Mr. Robert Mueller, who is a former director of the FBI. And that is relevant to this conversation. So this is declaration D136, part 3, segment 6. So this is the sixth part of the third segment of this cycle of declarations. Again, sorry for splitting them in that way, but it has been a long sequence, and it makes sense to keep it together, right? So in this segment, I want to kind of memorialize what happened since May 22nd, 2026, and today, May 27th, 2026. And to catch you up, if you watch the previous segment, I think that the part 4 of this segment, we talked about the Capias order, and the Capias order is an order. So it's a 3-step process, right? So the first process is the judge in the trial court signs an order for Capias, which basically instructing the clerk to issue a Capia and sign it and send it to the police to have me arrested. The second step is the clerk signs the Capias and sends it to the police. And the third step is the police arrest me, right? So they had that order signed, and I showed you in the part number 4 of this segment. I show you that according to the docket, they signed the Capias on the 15th. Okay, so the sequence of events in reality, according to the docket, right, from what we can see in the docket, was that the order for Capias was signed on the 14th of May by the judge, and then the next day, on the 15th, the clerk signed the actual Capias. Okay, that's the story, according to the docket. But crucially, so then I filed the petition for habeas corpus on the First Court of Appeals, and then they didn't respond to that, and then I escalated to the Supreme Court of Texas, and that's where it is right now, right? And in response to me escalating it to the Supreme Court of Texas, what they did initially was that they hid the index. It's still hidden today, index 213, which is supposedly the order for Capias, okay? The proposed order for Capias that eventually was signed by the judge on the 14th. They hit that index. They let persist the 214, which is the actual Capias, okay? I think they re-indexed it. I think they were reversed at the beginning. I have some versions of the early versions of the document in which the indices were reversed. But that's a small potatoes for what happened after. Right? So anyhow, what they did is that they posted on the docket on May 22nd the order for Capias signed by the judge, not the actual Capias. And that order for Capias got the index 222. Okay, let me check if my audio is set up correctly, because it happened to me once that I had this wrongly set. Yeah, it's okay. Yes, so they entered on May 22nd the order for Capias, but they didn't enter the actual Capias. Okay, in the docket, it's not in. It wasn't in the docket. Okay? Now, this on itself is irregular, because if they sign the order for Capias and then the Capias on the 15th, they have to enter it quickly, because I have the right to seek redress of that in higher courts, and they have to serve me with the order officially, right? Because I'm a pro se litigant, they're obligated to serve me with those 2 orders by mail, and they have to post a true copy of what they sent by mail in the docket, and it has to be downloadable. None of this happened, right? So they violated the process. But again, this is small potatoes. So from May 22nd until last night, the Capias was completely missing. I mean, the actual Capias, the actual order to arrest me. This thing was missing. It was not posted in the docket. And remember, it was supposed to be signed on the 15th. Now, importantly, the order for Capias, remember, the signature of the judge has the date May 14. It's written in the order for Capias. So it is not possible that the entry of May 15 is the order for Capias because the date doesn't match. Right? It means that the real Capias was signed on the 15th, but I haven't seen it yet because it's not visible anywhere. Now, in my petition for habeas corpus, I'm giving you this introduction because I'm not going to dig much more into this because this is the least interesting part. This was just like the build up to the escalation, right, of everything that happened after, which I think is the most interesting thing. Yes, so I haven't seen the actual Capia sign on the 15th. I haven't seen it. But my initial argument on the Supreme Court of Texas was that, well, like they're pressing it really on a de facto office arrest, even if the Capia is not posted in the docket, right? Because they don't post it because they don't want to commit to that position of the judge that I reported to the IRS is signing an order to have me arrested. I mean, this is, is very grave, right? He should recuse himself. But instead of recusing himself, he's signing an order to have me arrested. So they can't really post that in the docket, right? I imagine. I mean, that would be like the last recourse. I mean, if they really, are decided to harm, right? If they set their mind in really, going all the way, then they would probably do that. But until they don't, take that step, I think that order is probably not going to appear, right? I mean, they want sign on the 15th. But anyhow, so their I guess their tactic was to, signifying the docket that there was an order signed, right? By putting it 5:15, the court signs the Capias, right? So it's clear to me that there is a Capia sign that they could have me arrested, but the actual order is not in the docket. Right? So this creates a situation in which I have no recourse because I don't have the order. I cannot go anywhere and complain. Right? But still, I'm under a de facto office arrest, and this is more situational to me. Like perhaps other people that are in a different situation wouldn't be the case, right? But in my case, it is a de facto office arrest. And they know that, right? Because the opposing party knows my personal situation. My personal situation is that I don't have any family in Texas. So if I want to buy food, I have to go to the grocery store. And if I drive, they could have me arrested while I'm driving, and then they could impound the car. And then my situation would be even more dire, right? So for all practical sense, in all practical senses, I cannot really leave the office. So I'm basically entrapped, right? Which is what they want. So they're getting the benefit without getting the liability, basically, right? They have me constrained. I can't even leave the office, right? But they're not committing to the criminal position or having me unlawfully detained using, under the color of state law. They're not committing to that by putting that Capia sign on the 15 in the docket. But they're leaving the note in the docket, so it's hanging over my head forever, right? Indefinitely. I guess it's the worst form of imprisonment because if they have me arrested, I would just post the bond and get out, right? But in this way, I'm arrested indefinitely. I have no time. There's no time for me for this to end. This could be 1 month, it could be a year, like I don't know, right? I think it's the worst form of imprisonment that there could be. Anyhow, so that was the situation, right? Now, during this sequence on the 22nd, I think it was, an entry in the docket appeared that said M compel. M usually refers to motion, okay? But they didn't write the word motion, and they didn't write the word hearing. So it wasn't clear what this exactly is. It's an ambiguous entry. It could be anything, right? It could be a space for the judge to meditate. But anyhow, this is irregular because the court, and all these actions that they've taken are void because the court is under a mandatory stay, okay? Since January 14. So for all these months, the docket should have been frozen until the Supreme Court of Texas rules on the C-verified motion to refuse, which hasn't happened. So all these things are void. But interestingly, on Friday, there was an entry added to the docket saying M compelled. which I imagine it was a hearing, right? And it was scheduled for today at 9 a.m. Okay, but it didn't say hearing, by the way. So that was the situation, right? Now, when I see that, I started on Friday and Saturday, the 2 days, filing motions for de novo hearings. And I mentioned this before. This is a mandatory motion that the judge cannot ignore. This is specified in Family Code 201.015. So 201.015. Asking for a new hearing. And because they didn't invite me to the hearing was held without me, like all these due process violations, and the order and the order that was entered was not served to me, as I mentioned before. Like it wasn't served by mail as it should have been, because I'm a proselytical, and it wasn't served even electronically. And you can see that because in the order there is no certificate of service, which is attached if they had served it electronically. Anyhow, so I filed those motions. Of course, they ignored them, right? And I talked about this before. I believe this is a form of abdication, because the judge is ignoring a mandatory duty, not on one, not on two, not on three, but on 5 different motions for de novo hearings, distinct motions, are all of them mandatory. So he has to read them. He can deny them, but he has to address them. But he doesn't, because addressing them would confront him with the accusations of the crimes and the fraud against the court being committed, and then he couldn't ignore that. So he can't really address it. I believe that's what I think is happening. Like, that's why they're ignoring those motions. But again, it's a form of application. So I made all these arguments in the Supreme Court of Texas. Okay, and that was in the initial filing for the original filing for the petition of habeas corpus, which is case 26-0511 in the Supreme Court of Texas. But then interesting things started happening, right? So I filed those hearing motions on Friday 22nd and Saturday. Let me pick the dates because make sure that I'm getting this right. Yes, Friday 22nd and Saturday 23rd. Okay. So what happened was the weekend passed, Monday passed, and the clerk did not really process the envelopes. So the envelopes were never filed. Okay. On Monday. And usually I understand, like the rule says that it could take up to 48 hours. I understand that. But it was strange because usually when I file documents, it's a matter of an hour, 2 hours tops. Like this court doesn't have that much volume to justify the documents being hanging there for 4 days, right? Because I filed them on Friday, the first ones. So all the Friday, I understand Saturday and Sunday is closed, but at least all Friday and all Monday, right? So 2 business days, no action, right? Eventually, on Tuesday, the 26th, so yesterday, the documents in the morning get through. Now, interestingly, in the Supreme Court of Texas, there was an event in the calendar that said transmittal of records, something like that, scheduled for the 26th. I think this is an event that is marked in the calendar that signifies that the Supreme Court of Texas is going to take a snapshot of the case on the 26th. Right? So the play here, I think in reality, was that they didn't approve the envelopes, they didn't file the actual documents, so they wouldn't enter the docket. And when the Supreme Court of Texas takes a snapshot, they don't see these 5 motions for the novel hearing pending, which are mandatory and are a core argument in my petition, right? So in a way, it's a way to sabotage the petition, right? Because then one of the core arguments that I'm making, it's unverifiable by the Supreme Court, because when they take the snapshot, the motions for the novel hearings don't exist in the docket yet because they haven't approved them, right? So that's the first irregularity. The second one is that when they did approve them, the documents got a stamp with the date of the 26th. So Tuesday, May 26, 2026 at midnight. So 12:01 a.m., like the first minute of the night, of the morning of the 26th. But remember, some of these documents I filed on the 22, 4 days before. And this is another play. So Troy Pickett could go to that hearing today and say to the judge that he filed some documents, but he just filed them less than 24 hours ago. Therefore, I did not get proper notice. So therefore, we should ignore those documents. And the judge will say, yes, you're right. Let's proceed without even looking at those documents. Here's your sign order, right? Rinaldo, go to jail. So that's the plan, right? But what I did is that I filed a supplement with the Supreme Court of Texas, noting the discrepancy in the timestamps, and I attached the envelopes with the original filing timestamp and the first page of each document showing how they altered the timestamps. So now they have the problem that they can't do that. I mean, they can't play that line because now this is recorded on the Supreme Court of Texas. I imagine that it's a record that is hard to alter, right? It's probably heavily audited by federal authorities. Which is, I don't want to change the subject, but it's something interesting, right? Why the Supreme Court of Texas and the First Court of Appeals use a completely different docketing system that the foreign county court, right? Shouldn't they be using all the same docketing system? Maybe because the version of Odyssey that is used in the lower courts is intentionally weakened, right? So they can do this, I imagine, right? Anyhow, so this creates a situation that now they can't, they can't play that line, right? I mean, because now this is reported in a filing that was accepted by the clerk of the Supreme Court of Texas. It's filed, right? So now this is part of the record, and I mean, they can still do it, but there's going to be proofs that they did this, and it was reported to the Supreme Court of Texas even before they did it. So I mean, it doesn't even look sophisticated. I mean, as a crime, it starts looking clumsy, right? If the person you're committing the crime against is reporting the crime before it happens. I guess it gives a sense of how predictable this is, right? How repeatable this is. It's not because they're not smart. I'm not saying that. It's because they do it so much, and it's so standardized that it's repeatable, and therefore it becomes predictable and detectable, even before it happens. So they had to change tactics completely, right? And this is hours before the hearing today. Okay. So now this is where things start getting interesting, right? So and here I'm gonna kind of stop for a bit with the the topics on the filings themselves. And after I do this, I'm gonna walk you quickly through a couple of documents that I think are important and show you like key things that I've been discussing. But I want to like give you the overview first, and then I'm gonna quickly go through the documents, right? So don't make that part too long. Yes. So, when I see the M compel, right? Well, and compel means they're going to force me to do something that I haven't done, right? That's what compelling means. So I start thinking, what could that be, right? So I start looking in the docket, and I see that they filed a motion for compelled discovery on something like, I think it was April 21st, 2026. I mean, more than a month ago. Okay. I said, I remember that they didn't do this when the court is under mandatory stay. That's the main issue in front of the Supreme Court of Texas in this new case, 26-0511. Whether this court is acting without jurisdiction in this way that has no regard for law and the rules of procedure. Yes, so I see the M compelled, right? I see, well, they obviously, and I remember that they have filed that motion while the court was under mandatory stay. And that got on the back of my head, right? I mean, I didn't understand really what is that they were asking, what is that they were after, in that moment, right? But it stayed with me, like the thought, like they're after something. That was kind of the thought. Then I kind of stopped working on that for a while, and I started working on software, right? On my software projects, and I had a problem with that one of my computers died. And I had to replace it. So I started looking for within my office, because obviously I cannot go buy a new computer for two reasons. One, they're probably going to compromise it, and second, more than whatever I have is already compromised. And secondly, because I cannot drive, right? They could have me arrested, and they could impound the car. So I started looking for computers. There are different corporate computers that I could repurpose, right? All computers that I haven't used in in long time. Anyhow, I start servicing the computers, and I come across a computer that is an Apple computer. And when I try to see the computer, right, to see if I could use any parts of the computer, I try to turn it on, and it tells me that the password doesn't work, and if I want to reset the password, it says that it has to send a code to G Espina M. So sorry, it says I have to send a reset code to G and then a bunch of asterisks, and then add asterisks M at the end, right? So I look at it's kind of an obfuscation of an email, right? But the email starts with G and ends with M. So I look at that, and the only email that I know that could be is the email of the opposing party, right? The real party in interest in this case, right? And so, but I think, well, that's very strange, because this particular computer is not a computer that she ever used. This is a corporate computer that I was here at the office, right? But yet seems to be associated with her Apple ID, right? And this is a computer that the company assigned to her as part of the company, right? This is kind of a longer story, right? And I don't want to go too much into the personal side of things, but the company hired her. I mean, the company hired her to hire salespeople to help me sell the product. And she was paid a contracting fee. She was a contractor for I think it was 4 months that she worked for the company. And as part of that, the company assigned her a work laptop. It wasn't a gift; it was a work laptop, right? And she used it in the context of hiring salespeople, only for that. And that laptop is not the one that I tried to turn on, right? So anyhow, it seems strange, right? I mean, this mix up with the Apple IDs, like her Apple IDs being on the other computer that she didn't use. So it occurred to me that the play. I think I mean, this is what I thought right at the moment. The play is probably that they're going to make the discovery request is really to get property of that corporate computer, right? That's what came into my mind immediately. What they're after is that corporate computer, and then if she gets legal property of the computer, then that opens the door for something else in the future, like some other kind of litigation, like the one like that Terrell Miller loves, like intellectual property, right? So I do an experiment. I said, I'm gonna. I mean, I wasn't going to really do it, right? But to test the situation, right? So I sent her a message, a text message saying, "Hey, I have this computer here, and it's asking me for a code to reset the password. Can I send you the code to your cell phone, and you give it to me, and then I reset the computer, and I reset the password, and we're good." And then her replies was, "No, I cannot give you the code." And on top of that, she said, "And that computer is mine, I mean hers, because you gave it to me as a gift." So this is dangerous, right? So I mean, from my point of view, she is making a property ownership claim over that corporate computer, right? And this is crossing a line from my point of view. This is crossing a line from even if I mean, I deny the claim of the divorce, but even if it was a divorce, this is crossing the line between a divorce asset distribution and trying to get to claim property ownership on assets of a company. Like this is where there was a clear contractual relationship between her and the company. The company paid her a certain amount of money. There was an email explaining the terms of the contract and everything. Right? But it transcended that line, and that was yesterday, right? So, but I think honestly, I think this was a terrible mistake. Um, but now let me. I mean, there's a couple of things I have to take, right? So when yesterday, I went running to pick up some messages right here in the backyard. And I have to tell you, I did it wrong. Like I didn't rotate the keys correctly. I'm not gonna give much details, but the messages got damaged. I didn't get all of them. But this was after I had created already some filings, right? So I got some messages from this person that sends me information, and he told me, because in my filings I suggest that she is going to make the claim. He told me that yes, that's possible, but there's also another play. I mean, there's another variant. I mean, this is standardized. This is not something that they're just thinking about this now, right? Like this is something that they have done many times. And I'm mentioning this in case authorities see this video. This could be used for detection. What you could do is look for divorce cases in which there have been a dispute about a specific computer, and that that computer was used in a litigation for intellectual property somewhere else. Right? It seems like there's two variants of this. One variant is the other person makes the claim. Like in this case, the opposing party, in a year from now or whatever, she makes a claim on the intellectual property, claiming that I gave her the computer as a gift, and the computer contained X or Y technology, right, that I developed. And the contents of the computer were included in the gift with the computer, and therefore she owns that, right? That's one variant. But I think, I mean, if you ask me, from my opinion, I don't know. I have to do research to see how many times it has worked, right? But I think it would be too obvious, particularly in a contentious case like this, right? Like I think authorities would see, or a really impartial judge will see through this, right? So the other variant is that the wife or partner of the the target sells the computer after the divorce is final, and the computer is acquired by somebody who is connected to a company that had a working relationship with the target in the past. Right? And then they can alter the file system, inject files, or whatever they need to do. Right? The chain of custody would be compromised, but if they control the judge, that's no problem. I mean, if they can enter void orders under a mandatory stay, and not one, but like 5 void orders, with very serious restrictions on even liberty, right? They can easily bypass the chain of custody problem. Like the chain of custody, because say that she sells the computer on eBay, right? And then somebody buys it on eBay and then says, "Oh, I got this computer," followed by something like, "And surprise, I saw this," right? And this means that this technology belongs to whoever, right? Uh, there will be a question about the chain of custody because the computer was sold through eBay. And there's no guarantee that that person didn't manipulate the computer or whatever, right? But if they control the judge, they can easily bypass this. Right? The judge can say, "No, this is not a problem," and then sign the order. Right? So this is the other variant of the same play. But this is what they were planning, right? So the whole thing for the discovery is not about it's about discovering so I produce an inventory, right? And then the order will assign the corporate computer to her, and then she has legal ownership of the computer and its contents, right? And then that's put my intellectual property in jeopardy, right? Now, I have to tell you, this is not something new, right? This started more than a year ago when Morgan Heitner and William Kell Adams filed initially, when at the case inception, when they filed the first papers. The first thing they did was to file an injunction clause, a boilerplate clause for injunctions, that said that I was prohibited from selling, transferring, I don't know, something like that, right? Selling, transferring, I don't know, computers, computer equipment, computer media. Like they were interested from the beginning of the case in the computers and the computer media. But that was in the order that was never really signed, right? Like in the unsigned notice of hearing that they sent me. It was in a notice of hearing, but it was worded as if it was an actual order. And I discussed this before. This is the TTP that they applied to trick me into believing that there was no temporary restraining order, right? They sent me this notice of hearing with a bunch of clauses that looked like an order, but it wasn't really an order. And I described this before, right? How this works. So in that sequence, they from the beginning inserted language, with that shows that they have interest in these computers, right, and the media. And remember, at that point, the patent applications that are the center of the controversy at this point in May 2026 didn't even exist because I filed those patent applications in March 2026, almost a year after the secret temporary restraining order that they have, index number 7, was signed. Right? Anyhow, so that's the play. Now I have to tell you, I'm going to tell you this. Sorry for changing topics and going back for a bit, but because I will forget if I don't tell you this. In the previous part, I mean, just a few minutes ago, I told you that my filings were held for days, right? And the goal of that was to create the narrative that I had just filed them hours before the hearing, and therefore they should be ignored. I have to tell you something that I thought that I had. I don't know if this is the case, but it's possible. It's likely, I think. Like, I'm telling you this as an engineer. Right? I haven't seen what they did to delay them, but I think the delay is not really created by the clerk. I think the delay is created by Tyler Technologies, by withholding the envelopes. And I'm telling you this as a software engineer. Right? I mean, there's a bunch of technical reasons why this would be the easiest, more scalable way to do it, and the less risky. Because this way, I mean, imagine that you have a queue of envelopes, right? And Tyler Technology has the ability to, pause items in the queue and let items that are behind the queue jump over the ones that are held back. If you had this infrastructure, you could hold envelopes in the queue indefinitely if you want, and the queue will keep moving, right? Unlike a regular queue. But this special queue, if it works this way, the items that are not held can keep moving, and the ones that are held are static, right? So this way, it works better because then the clerk has no liability. In fact, the clerk has to have no knowledge of what's happened, right? The clerk might not even be seeing the envelopes in the queue coming in. So she doesn't know that this manipulation of the record, I mean, it's a theory, of course, right? In this scenario, she doesn't even have to know. And that's better because if there's an investigation, the clerk has no information to give to the authorities because she really doesn't know. She didn't see the envelopes. They didn't come through. And it's also more scalable. Why? Because then you don't have to rely on a network of corrupt clerks to do this, right? To withhold the documents in this way. You can withhold them, the ones you need to withhold, in the aggregator, right? In the software system that manages all the envelopes. And that way you can do this in 24 states, right? You don't have to be training clerks on how to manipulate these things. So it's a more scalable thing. It's a more scalable way to do it from a human point of view. So I think really the envelopes were held at Tyler Technologies, which, would align with what I said for my findings on Declaration D132 and 31 and 33. So yeah, wanted to tell you that because I'm going to forget. So going back to the issue, right, of the unserviceable computer, the refusal to give me the code to service the computer of the company, and then the immediate claim of ownership over that corporate computer, saying without even looking at the computer, because she is just receiving this WhatsApp message. She doesn't know. There are many computers in this office. She doesn't know which computer I'm talking about. But apparently she knows, right? Because she immediately told me, you gave me that computer. She talked in singular, like she referred to a specific computer without seeing it. I didn't give her the serial number. I didn't give her a photo of the computer, nothing. She has no way to know which computer I was trying to reset. But yet she made that claim. So I understood that that's the payment. And the informant told me that there's variants. There's different variants in which they could execute this. But the important thing is that it gives it produces a sequence of events that produces a legal transfer of the computer asset from one hand to the other in a way that is sanctioned by a judge, because the judge is the one that is going to sign the order saying you're going to get this computer. So then this would be legal property of her, and she could do with that computer whatever she wants and with the contents of that computer. So this is very sophisticated. Right? And I think this is an important thing that I thought after I discovered this, right? Because this always was in my mind, and I haven't said this before, but I know, and I've known this for months. And also, this guy told me months ago that this was the case. In one of the occasions that they broke into this property, they stole my 2 iPhones. I had 2 iPhones. I think one was version 11 and another one was version 13, if I recall correctly. At this point, they're old iPhones. I don't use them because they're heavily locked, right? And I had them in a storage room upstairs. They did disappear. Those iPhones are nowhere to be found. And I had them stored in a special place because I'm saving them as evidence because I know they bought them more than every other iPhone in the world. Or well, maybe there's others that are more bought, right? But these are special, especially the 13 one, because that was purchased after I had created key opinion leaders. So anyhow, the iPhones disappear, right? And it always, bugged me something, right? Is that I couldn't understand why they took the iPhones. I mean, and this is kind of funny, right? I mean, at this point, I have to accept the fact that they can break into the property whenever they want. Like I'm not even surprised, right, that they stole the iPhone. But that's not what surprised me. What surprised me is that they stole the iPhones, but they didn't steal the computers that were next to the iPhone, the Macintosh computers, which are also bought. If you're going to steal, I mean, if your goal is to disappear evidence, like the iPhones, right? Why not disappear the MacBooks that are probably more bought than the iPhones, I imagine. Right? If you want to steal something, steal the computers, right? But they didn't take the computers; they took the iPhones along. This is the reason. It's because they need the computers to stay in my possession. So eventually, when a divorce happens, a judge that is working for them signs the order assigning the property of the computer to her. And that is what allows, that's the vector to steal the intellectual property, is that computer, right? So that's why it was important that the computer remain in my property for as long as needed. They would deploy this weapon later, right? Like for now, this was going to be a standard divorce, quote unquote, case to harass me and strip my parental rights, everything. But the goal wasn't to steal the intellectual property now, right? That's why they're leaving the computer there. So eventually they're going to deploy that at the end of the divorce, right? When the divorce is going to be finalized, the assets, who gets the car, who gets the computer, blah, blah, blah. Then they transfer the computer to her. I imagine they will wait a little bit and then, they will deploy the weapon and, extract the computer from her in a way that is also legal, right? That also leaves a legal trail that they can act upon on an intellectual property dispute later on. With either of the two parties, right? Whether it's her making the claim, which I think would be a stretch because she was an engineer, right? She could claim that, well, she collaborated on the project or whatever, right? But she was hiring salespeople. She cannot make that claim, right? Even if she has possession of the computer. So that's why they have to transfer it to somebody else that could make that claim. Anyhow, that's why they didn't take the computers, right? When they stole the 2 iPhones, because it's important that the transfer is signed by a judge. It's like when they do this thing, like they want to pay an agent, they create a fall in an apartment in New York in the Mandarin Oriental, and then the person sues the Mandarin Oriental, and then the Mandarin Oriental creates a settlement, and that's the payment. Right? It's the same thing, right? But I mean, the judge is the one sanctioning the transaction, right? Legitimizing it, right? Making it legal, giving it legal legs, so to speak. That's the idea. But I think this was a terrible mistake because, well, first of all, it opened my understanding of things, right? When I see this, right? I mean, it's like until now, right? Troy Pickett has been going to court making this, making all these claims and motion for sanctions and all these things and playing it as if this is a divorce, right? A divorce case. But now they're making claims over ownership of corporate computers owned by a company. Right? They're crossing a line. And it's not only they cross the line, right? Because crossing the line alone doesn't make much because they control the system, right? Who I'm going to complain to. But it opened my understanding, right? And so what happened next is that I started debugging this. Like, okay, so when this happened, looking at the timeline, when is that Troy Pickett filed those documents for that discovery? Because they could have filed that in December when the court wasn't on the mandatory stay. Why do it on May 21st? why trigger all this all of a sudden on May 21st when it's more risky? Because I reported people to the IRS and to the OFAC and like all those things. Um, I don't know. It doesn't make sense, right? So I started I started debugging, right, trying to understand what triggered this, and I found it. I'm pretty sure I found it. So let me show you. This is a good point for me to share my screen with you. Okay, so now I'm going to transition back again to the legal topics and the documents and all that. So what happened after I disabled the narrative of third picket, I mean, what they had prepared, right, of saying that I had filed the motions and the objections less than 24 hours before the hearing, which is not true. When I disabled that by filing directly the motions putting the Supreme Court of Texas on notice that these motions were filed on the 23rd and that they are manipulating the timestamps, probably using teletechnologies. Of course, in my motion, I didn't say teletechnologies because the person directly responsible for these timestamps, in my eyes, as a litigant, is the clerk. It's not teletechnology. So I mentioned the clerk, right? Now the clerk, if she's question about this, I imagine she will have to say, I didn't see the envelopes. And the next logical step, if you're debugging this, is, well, how does these envelopes come into possession or not of the clerk? Well, you have to ask Technologies and look at the Odyssey logs to see what happened to those envelopes. Right? It's the only thing that is a logical thing that any engineer would do. Anyhow, after I disabled that strategy, then Troy Pickett filed with the Supreme Court of Texas. No, first he sent me an email. The email said, attempt to conference. And this is not the first time he does this. When he gets desperate, he sends me an attempt to conference email. And this is usually an email that is, the title, the subject says that he's attempting to conciliate, right? To calm things down, to work things out. But if you read the email, it's the opposite. He is threatening me, right? And attacking me, right? But he has done this 2 times before. Yes, 1 or 2 times, I can't recall. But in this new instance, basically what he said was that I was filing too many documents. I mean, I'm going to paraphrase, right? More or less, this is what he said. And that my motion for habeas corpus, my petition for habeas corpus was baseless. Basically, he's saying that I'm not going to be arrested, that I'm wrong, right? That I'm just misinterpreting the docket because I'm crazy. So this is the new narrative. So he seems to me like after he saw that he could not do that thing of, this was filed late, he is now building a new narrative. Right? I mean, he did this last night. So he sent me that email saying, I have this motion for sanctions, and he sent me the draft. So he's threatening me, right, with more sanctions. I mean, he already has like 3 orders for sanctions, all signed by the trial court, while the court is under mandatory stay. So they're void, but he has them, right? And he produced them, he created them. But this was a new motion for sanctions. But this one was to be filed with the Supreme Court of Texas. So now he's going to ask for sanctions on the Supreme Court of Texas. And he did. He filed this morning. And this time he's asking for an additional $10,000 in sanctions. I think if you sum them up to date, all the 4, if this one gets granted, he would be accruing more than $20,000 in sanctions alone against me. Right? So to give you an idea of the harassment that they're applying. So he sends me that, right? He says that, but he gives me, quote unquote, an out. So if I don't want this to happen, I mean, that he executes and makes good on his threat, he gives me the option that I have to withdraw my petition from the Supreme Court of Texas. And not only that I have to stop acting as a pro se litigant because he's implying that I'm creating a problem for the court and for him. Right? So to solve his problem, his solution is that I stop being a pro se litigant and I retain counsel, like the Adams law firm, right? In the best scenario, I imagine, for him, I would retain William Call Adams. And then William Call Adams and him can work it out on my behalf. Right? But this is an atrocity, right? So the opposing counsel is trying to coerce me to control my own defense, And not only that, he wants to strip me from my right of self-representation, which is a right. I think this is in the Constitution. I don't know. Like, this is a fundamental right. I have the right to represent myself. And he cannot be, threatening me with anything to remove that right. I don't know. I think it was a desperate measure, right? But at the same time, I think it was a mistake as well, because now, and then he filed that this morning, and now the Supreme Court of Texas has that filing and my filing, and then, so now the Supreme Court of Texas has filings from the two sides, and they have to act on that, right? Like, I mean, if it's only one side filing documents and the other side doesn't respond, they could say, well, we're waiting for the other side. But if he filed that, you know, side note, when he filed it was funny, right? Because he's calling me basically incompetent, right? That I don't know what I'm doing. That I don't understand the Capias order that he created, and I think I'm going to get arrested, but in reality, I'm not. That's what he's implying, right? Because he's saying that I have no basis for the habeas corpus. No basis means that I'm not going to get arrested. So he's basically calling me incompetent, right? But I mean, for filing documents on my own behalf, for my own representation. But what's funny is when he filed his motion for sanctions, it got rejected by the clerk, because he forgot to add the section. There's a certain mandatory sections in the when you file things with the Supreme Court of Texas and the United States as well. Certain things that are mandatory. You have to. There's a certificate of compliance that you have to create, and a certificate of service, and there's certain. And he didn't create the right certificates, and he was missing things, and his filing got rejected, and my file got approved. So, I mean, this directly contradicts what he's saying. How is it possible that a pro se litigant is more capable of filing a document with the Supreme Court of Texas than him? Because mine get approved and his got rejected. Anyhow, I think that was hilarious. But let me tell you why Tropica took that step. It wasn't only because I disabled the strategy for the hearing with Telfair. By the way, when he procured that order today, he at the end procured the order for discovery, right? He has that order. Now, that order was signed by a judge that is not Telfair. The signature is illegible. I cannot tell the name of the judge by the signature, but I can tell that it's not Telfair, because Telfair has entered so many void orders against me while the court is under mandatory stay, that at this point I recognize the signature where I see it. If I see it, even in a separate document that has nothing, that doesn't have this case number on it, I understand that that's Telfair's signature. I know it by this point, and I see that this signature is not Telfair. Now, it's not Richard Bell either, because I also recognize that signature, and because Richard Bell was transferred to a different court in October or November 2025. In one of the hearings that I went, I think it was the January 22nd, I saw that the associate judge or magistrate judge, I don't know, I don't recall how is it called in this court, but there's two different judges, like Telfair, and he has like a subordinate judge that helps him, like an assistant judge. Excuse me, I may not have the terminology correctly, but it's just the second in command in the court. In the January 22nd meeting, there was a judge there that wasn't Richard Bell, and that's how I understood that he was changed. And then I looked him up, and I saw that he was promoted to, main judge in a different court. I think it's the 505 or 501, something like that. So anyhow, this other judge is a lady. It's a woman. It's a female judge. She is like, I don't know, probably 5'6", 5'7". Yeah, it's a woman, maybe late 30s, early 40s. I would put her on that age range. I haven't looked at the pictures. If I look at the pictures, I'll recognize it. So I imagine this is her, or maybe Troy Pickett. I mean, in reality, like what he did was to go judge shopping, right? Because there's been so many void orders signed by Telfair without jurisdiction that if they're overdoing it at this point, right? Like he has to round robin the judges at this point, right? So many orders that he's creating, void orders, that he has to round robin now. Anyhow, that's one of the improprieties of the order. The other one is that it's an order for compelled discovery, giving me a time window to produce the things that he's requesting. But this is so sloppy. In the time window that he gave me, instead of putting 2026, he put 2027. So he's giving me more than a year to give him the discovery. And there's other improprieties, like She didn't serve me with the order. It hasn't been sent to me by mail. Maybe after every court is demo, they will send it. But importantly, the order for Capias and the Capias itself, they were not served to me by mail, and they should have, because they're orders, and I'm a proselytic, and they have to serve me. The clerk has to mail me these documents, and they have it. And remember, the Capias was signed on the 15th. So today being the 27th, 12 days after, and this is an order that could put me in jail, they haven't mailed me a copy. Right? And so this is a systematic violation of the process. Like, this is what they do. They enter orders, and they don't send them to the, so I don't have a copy, right? And even if I appeal it, if I get a copy somehow, they will say that's not the real copy. You made a mistake. This other one is a real copy. And because they never served me an official document, I cannot prove that this is the real copy. You see? It puts me in a position where even if I appeal, I will lose the appeal, because they will say that that's not the real order. They can change the order anytime they want, because I don't have a copy of it. Only them have a copy. So that's basically how it is. Yes, but anyhow, let me show you why I think it's a threat ticket did all this, right? And this is, so I'm going to go back to to what I was telling you before, that when I see the sequence of the computer and the thing with the password and all that, and I see, right, that basically the mask came off, right? Like, this was a moment in which I was able to see, with my own eyes. I mean, I've known that this is not a divorce case. I know that, right? I've known that for a year. But like, seeing a message coming from her number claiming property ownership over a computer, right? Instead of being, she's not making claims on the cars, on the house. Like, she's making a claim on this inexpensive computer, right? So, it was a moment in which I was able to see, right, for the first time, like, eye to eye, I guess. So this led me to start debugging, right, when this sequence started. So anyhow, let me see if it's in this document. Just 1 second. Yes. 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 So this timeline here is what I want to show you. So this is basically what happened, right? On April 27th, I mean, this is a theory, but the timeline is very suggestive. But this is probably what happened. On April 27th, I sent via registered email to a set of recipients. One of the recipients was, let me tell you exactly what this is first. Okay, this is something called DFARS 227.7004. This is a claim form that you can file with certain officials in the U.S. military, for example, that work in procurement. So basically, the ones that assign contracts to third-party companies, like Microsoft or Lockheed Martin, things like that. And the way I'm using this form is to report, to put these officers or officials in knowledge that I have this portfolio of 50 plus patent applications that are pending before the USPTO, and that I have granted to and I described this design in one of the demos before. The idea is I put the person on notice that these patent applications exist, and that the US government, the federal government, has a grant of a license to use these technologies for free, without a royalty or anything, or a license or anything, perpetual, right? And I explained in a previous declaration why I did this, right? There's a strategy behind this, but it's too long. I'm not going to get into those details here. But that's what I did months ago, right? I granted those licenses. So the idea with this form is usually if you want to report that a contractor is misappropriating intellectual property or is infringing upon intellectual property, things like that, right? Because the procurement officer has to be in knowledge of this, because the government cannot be paying for a product or a service that is infringing upon the intellectual property of somebody else. But here I gave it a spin. The spin was, I'm not making a claim to the government. I'm not saying, pay me. On the opposite, what I'm saying is, you may have contracts that may be for goods or services that may be infringing on these inventions for which you already have a license that is free and perpetual. So you may be paying for something that should be free. At least that part of the product should be free because you have a license for that. You shouldn't be paying any contractor, an external contractor, for something that you already have a license to use, right? So what I'm telling to the procurement officer is, you have a way here to save money for the taxpayers, right? And this was nuclear because, if the officer ignores that, I think that would amount to corruption. So they have to take an action, at least investigate, right? And this means reading the book of patent applications, which means reading the declarations that I put inside, the legal declarations, right? Which means reporting Tyler Technologies and BlackRock to the authorities, right? To the federal government, because these are already the federal government. Right? So it's a nuclear weapon. Right? So I did this on April 17th, and I sent this to military officers, and one of those military officers was Emil Michael, right? Because he's not a military. I think he's civilian, right? But he is under military. Like, he's the Undersecretary of Defense for Technology, something like that. But this is, and I mentioned this in one of the demos. That demo wasn't on video, right? But it was a recording I did driving like 2 months ago. But it's funny to me because Emil Michael has been one of my technical adversaries for years. He worked with Travis Kalanick for at Uber, right? In that coin thing that they had going on, that they have been using for decades to harass people, right? In this way that they harass it today, up to now, right? And not only that, Emil Michael, when I started building key opinion leaders, he acquired an important interest on Workrise. And he was sitting on the board of that company, and then he employed my former partner. The opposing party in this dispute was employed by a company controlled by Emil Michael. So he gave her a computer laptop that she would bring to my home and connect to the Wi-Fi and to the network. Right? It's nuclear, right? So now, because he's now the Undersecretary of Defense, I sent him that DFAR, right? Putting him on notice that the government has a free license for this, and they shouldn't be paying companies if they are using for products or services that are misappropriating this technology. Right? They have to at least audit those companies. And I specifically, in this one of the April 17th, it was about Lockheed Martin, because they have contracts for things like the F-35, the fighter jet, the F-16, and those jets have enormous databases. Right? So those databases, if they already converted them to something that infringes on my inventions, or if they do in the future, the government would have the right, I think, to ask for a reduction in the price, because they shouldn't be paying for something that they have a license for. That is what I'm saying in the DFAR. So I filed this DFAR. I understand, right? This, when I tell you this, you may think, well, this person is crazy, right? He's getting into waters that are too deep. It's true, right? But in this situation, I have to do it, right? Because otherwise, they are not going to roll this back. So that's what I did. This DFAR, it's not like this DFARs, it's a form, it's a standardized form produced by the federal government. Like, this is, this is something that it's a recourse that anybody has. I'm exercising a right that I have in sending this form. They could get upset. They could tell me to shut up, whatever, right? But they cannot go into the family court and escalate a discovery track for corporate assets using the divorce as a pretext. That's something that they can do, and they did, right? So, and I say that is because I filed that on the 17th, April 17th, and Troy Pickett on the 21st filed his letter of dispute for the discovery 4 days after. And I haven't checked. Let me check what is the. Let's see what is the calendar. I don't know, calendar. I want to see if the 21st. What day was it? Yes. See, so I filed it on a Friday. I filed that thing, and I want to show you that I have the receipts and everything. So the reason why they didn't sooner is because it was Saturday, right? And they couldn't file the motion for discovery on a Saturday. So basically, one business day after I filed the defarce, they started with the harassment with the discovery request. Like they hadn't done that until I did the defarce. So I see causality. Like it's because like the for example the F-35 contract is $1.7 trillion, something like it's in the trillions. It's a contract that lasts many decades, but we're talking about trillions of dollars. Right? It's not billions, it's trillions. So this is the kind of money that countries move, right? And when I saw this, I saw, well, it makes sense. And in one of the declarations before, I think I mentioned this. I mentioned that I understood at some point, right before last year, I was reporting people and companies to the IRS, and were people and companies worth billions of dollars, and they would not roll back the case, right? And I understood at some point, I said, I understand now that I have to target trillions because, things are worth trillions because these people are countries. The network operating this thing are countries, and they only care about trillions. Billions are quantities that are too small for them. They don't care. If they have to lose 50 billions to get out of this, they will lose them. It's nothing, right? But if they have to lose $2 trillion, then they will think twice, right? So this makes sense. When I send that defarce for something that touches on more than $1 trillion, then they escalated on the family. Troy Pickett. So I think that's the thing, right? So if you look at the docket, let me show you the docket here. I think I have it somewhere. Yes. Yes. So you see, on 420 on April 21st, there is a letter posted, and it says required discovery dispute letter. So see, on the 21st, Troy Pickett initiated the track of creating this dispute about the discovery that at the end resulted in the Capias order and in the hearing that he had today ex parte with a judge that he shopped for. This was one business day, singular, after I filed that defarce. And I'm going to show you the defarce in a second. And then, he filed the motion to compel 7 days later. So the actual motion, he took 7 days to file it, but the letter stating his intent was filed the next business day. There's a letter saying that there is a discovery dispute, right? Which is what all this is about. So I see the causality there. Now, this is a terrible mistake. The escalation with the Capias and all that, because then when I see this, of course, what I did was to put this into my file, right? As you can see here. And I filed this with the Supreme Court of Texas, right? And it's accepted. The filing is in. So now this, now, because it's not only because I saw it. It's because she also made the demand for the computer, right? Which ties this, the quote unquote divorce, directly to the discovery request and to the defaults. Because if you have a contract that is worth $1.7 trillion and there is somebody with some inventions filing a default that could put that contract in jeopardy, 2-1-2, right? And you can see, and also filed in the Supreme Court of Texas, the messages. The messages and so they're translated into English, and also the Spanish. They were in Spanish, and there's also a screenshot of the actual message. But this is also in the Supreme Court of Texas. So the whole thing is exposed, right? You can see direct correlation between me filing that defarce and Troy Pickett starting this track of the discovery, and then the request, and not the request, but like the claim, the direct claim on ownership of a computer without even seeing the computer, right? Is what they do. Like, they send these text messages crafted in a way to seed something that can be used in litigation later, but it always backfires like this, right? Because I know what they're trying to do. If I didn't know, maybe it would work, but I know, right? But the reason why all this is nuclear is not only because it's in the Supreme Court of Texas, but because remember, I sent to the Honorable Heidi Shue and Emil Michael a letter explaining to them that they had this free license. And I did this months ago, in early April or late February and late March, I think it was. Months ago, I sent this to them. Right? In fact, the letter is here. You can see the Heidi Shue version of the letter is here. I sent this on around March 12th, I think I sent it. And there's the full letter here, and I attached the book with all the patent applications. So I sent this to the Department of Defense on March 12th, around March 12th, and to Emil Michael shortly after via email. And he opened the email and received it. I have the receipt. So of course, because this quote unquote divorce case has now crossed the line towards a dispute on a computer asset that then they could use, my technical adversaries, to make a claim on intellectual property that could affect these patents that the federal government has a free license of use that is perpetual. I need to notify these entities in the federal government that this dispute is going on. So therefore, I added them to the legal service of this Supreme Court filing. So if you go to the certificate of service, you can see, right, here is G. Troy Pickett, William Kyle Adams, Morgan Heibner, Oscar Telfair, the judge, and you see here Lieutenant General Mike Schmidt, who is on the F-35 Joint Program Office, and the Honorable Emil Michael, right? And you can see that their email addresses are us.af.mil in that domain for one of them. And for Emil Michael, it's on mail.mil. So these are military mails. This means that this electronic service coming from the Supreme Court of Texas is going directly to the Pentagon. And all these documents that I'm filing from now on this Supreme Court of Texas are going to go to the Pentagon. So, Troy Pickett filing for that motions for sanctions, trying to put me in financial ruin by imposing sanctions. At this point, if you combine them, I think they sum up to almost $20,000. And he initiated this track one business day after I sent that DFARS to Lieutenant General Mike Smith. And you can see that because I'm going to show you the exhibit. And all this is included in this exhibit that is filed with the Supreme Court. In this track. So this is the actual DFARS. Right? So the title says, Formal Administrative Claim for Patent Infringement under DFARS 227.7004 and Notification of Procurement Irregularities Concerning Perpetually Licensed Technologies. Meaning, if these contracts that they have with these third-party entities, if those services or products are infringing on any of these inventions, they need to review the prices. Right? Otherwise, it would be an irregularity. And in this case, you see that I sent this to the officials on the government side, on the military side, but I also sent it to the general counsel or the outside counsel of Lockheed Martin. Right? So Lockheed Martin is on notice, legally speaking, because notice to the agent is notice to the party, and notice to the party is notice to the agent. So they're on notice. Like, they didn't respond to this, and if you're on top, like working for a company, a defense contractor of that size, and you see these, I think you have an obligation to respond, right? But they, of course, they don't respond because responding would be acknowledging notice, right? So they don't respond. But the problem is that Troy Pickett is escalating this attack on the family case and now this is on the Supreme Court of Texas, and they're making this demand for this computer, and I need to notify the federal government that because there is a financial stake that is potentially worth a lot of money that could be in jeopardy. Like, I have an obligation to include them. I cannot, not include them. And I imagine they would have an obligation, like Neil Michael would have an obligation to look into it. So anyhow, after I did this, is that Troy Pickett went and refiled, because his first attempt to file the motion for sanctions got rejected because he didn't do it correctly, right? He didn't know how to do it. So he got rejected. He learned how to do it, and then he tried again, and it got filed. So the motion for sanctions is in the Supreme Court of Texas, waiting for ruling. And then he went judge shopping and got this signature from this other judge on the motion for sanctions on the trial court and for the discovery. But he gave me more than a year to do the discovery until 2027. But the other violation that they did, this is pretty serious, right? And I filed a supplement about this. They marked the case as inactive. Okay, this is kind of funny. Let me go there. Yes. So the case, they marked it, and there's when a Capias order is issued, there is a procedure, right, to mark the case as, this is not unusual, right, marking the case. But what they did is that they took that opportunity, and when they entered the Capias order today, yesterday, sorry, you can see that it says here 5/26, right? It says Capias issued failure. By the way, it says failure. It's misspelled, right? F-A-L-I-U-R-E is misspelled. So a human typed this. This wasn't an automated system. This was a manual intervention. And this is the docket index 231. But anyways, the important thing is that they put in parentheses inactive status in the Capias, right? So what they're implying is that the Capias is inactive. And this is nothing more than, again, the same deceptive title, TTP, that we talked about to death in the last year. They've done this at least 5-6 times in this case. The whole idea here is to trick the Supreme Court of Texas into that the Capias is there, but it's not really active. They're implying that the Capias is inactive. And that's why Troy Pickett, in his motion, is making that claim that I have no basis to ask for an habeas corpus, and that I'm crazy, that I just don't understand how the docket works. So what he's saying, I mean, this action of the clerk of manually editing this title and putting inactive status in the Capias is nothing more but something to reinforce Pickett's narrative that the Capias is not real. But it is real. I click on it and I download it, and it says Capias. It doesn't say inactive. The actual document, I don't know if it's gonna let me download it, because sometimes they do this thing where they block the documents. Let's give it a try. See that it says inactive, right? This icon here says inactive. It means inactive. So this is the actual order to have me arrested. So you see, it says Capias. It doesn't say inactive anywhere. See? I'm searching for inactive, and the word inactive doesn't appear in the document. So that inactive is only in that title. But that is just to justify what Troy Pickett is saying in his filing with the Supreme Court of Texas, to make the Supreme Court of Texas believe that the Capias is not real. It's not active. Like, they're not going to really arrest me. Right? It's just, we were kidding, kind of thing. Right? But this is serious, right? Because they're manipulating the docket on the trial courts to prevent me from having redress on this violation of the process. Now, there's another problem with this order. The date here says May 26th. And this is improper because, if you remember, if you look at the docket, the Capias supposedly was signed on 5/15. Right? You see here, it says 5/15, judge docket entry, court signs Capias, and it says Oscar Telfair. This is not the order for Capias. The order for Capias was signed on the 14th, and I had a copy of that. This is the actual Capias. But the Capias that they posted on the docket last night, on index 232 has a date of May 26. No, in fact, they posted it today, say 5/27, this morning. The index it got, no, sorry. This is the new order that they got. The Capias is this 526, the index 231. Sorry. This Capias, which is the one that they mark as inactive status, that Capias, I mean, they put it in the title. The Capias is live. This is not inactive anything. They could arrest me with that order. But this is not the one that they signed on 515. This is a new Capias. So, like now they have two versions of the Capias. They have one in 515 that I don't even know what the bond amount says. The bond amount of that one could be $25,000. I don't know. And they have this other one that says $2,500. Right? So maybe they can switch them. If they really want to harm me, they can switch them. And maybe the other one is an amount of money that I cannot pay and I cannot get out of jail. Right? And then they win, and then they seize the computer because I'm in jail. I cannot. So they send a police officer to fetch the computer while I'm in jail, right? Something like that. I don't know. But anyhow, it's another violation because you see the docket entry says 5. Even if this was the Capias, right? Even if this was the one, the docket entry says 515. And then this other one says 526. So for 11 days, they've had me in this state in which the docket says that there is a Capias for my arrest, but they haven't posted the actual Capias. Right? So I think it also serves to disarm the narrative that what I'm telling the Supreme Court of Texas, that they have me on a de facto imprisonment here. Because what they're saying is, no, the Capias hasn't existed until today, until the 26th, like when they signed, which is not true. The docket says that it was signed on the 15th. And even if it was true, the fact that it's on the docket, it's enough for a pro se litigant to fear that he's going to be arrested. I mean, it's more than reasonable to think that if I go out in the car, they're going to arrest me and impound the car. I mean, I have no reason to think otherwise until they don't remove and squash that from the docket. All the things that the Capias. If there is one thing that says Capias in this docket that is not squashed, I fear that I'm going to be arrested. But who would not think in that way? Anyhow, but to give you the closing thought here is that I think all this was a terrible mistake because well, I don't know if it was a mistake. Like I don't know. I think the thought really is that what happened is that DFARS that I filed precipitated their timeline. Right? Like if I hadn't filed that, maybe they would have deployed these rules with the computer and the discovery and all that, maybe in 6 months or in a year from now, right? But because I filed the DFARS and the emails that go to the Pentagon are ingested automatically into a system that indexes them, right? So if you send an email to an official in the Pentagon, like this gets into a system that gets outed. Like you cannot just delete an email in the Pentagon, right? Like this goes to a data lake or something that is perpetual, right? Like, or has very high durability. So the moment I sent that DFARS, I imagine some clock started ticking. That's why they had to precipitate this, right? I mean, the play with the computer and the discovery and the partition of the assets and all that. But again, it was a mistake because then, I responded. And it escalated to the Supreme Court of Texas. And eventually, Emil Michael, and other military officer, got added to the service, which also gets ingested into the email system of the Pentagon. Right? So now the Pentagon and everybody who's watching that system knows about this litigation in the Supreme Court of Texas and what Troy Pickett is doing, and the sanctions and the void orders and the timeline and everything. Right? Like I think it's probably going to be one of the most expensive legal mistakes made in the recent legal history in the US, right? Because that contract is worth trillions of dollars. I don't know. I have to do some research to see if there have been legal mistakes that could go above this legal mistake of Troy Pickett. But maybe he will earn a place in history, as the person that made the most costly mistake in legal history. It's possible. Let's see what happens. But with that thought, I'm going to close this one, and I'll see you on the next one.